Thank you, Denver, for this very long introduction. With the benefit of hindsight, I should have shortened that CV considerably, so my apologies. Good morning, colleagues, guests. I was actually very happy to see management go, because now we can relax and we can really engage. And I'm talking to you about a topic that's really close to my heart, intellectual property. What he didn't say was, I started at UNISA in 1991, so I've been here for a long, long time. And UNISA and UNISA's lack of management of intellectual property is a bee in my bonnet. And it's been like this for a long time. So, I'm going to talk about just a very quick, this is not a lecture on IP, but just a very quick introduction to intellectual property. You know, there are 3 IP. Once I spoke, and I will never forget it, at a conference on contract management. And this person who introduced me said, well, he's heard about IP, like the IP address. He's heard about IP. And now he's hearing about the third one, intellectual property. Of course, that middle one was a very, not a very, in good manners. So, I'm talking about intellectual property. I want to talk about the current position. I'm going to draw a little bit. I was involved in the IP strategy project. Our former Pro-Vice Chancellor, Professor Beishanov, led this. And of course, nothing has happened. And I'm going to tell you there are 4 imperatives why we should see this as a huge risk and why we should do something about this. So just very quickly, when I talk about intellectual property, what do I mean? You can see the IP atom. At the center, we have function. And normally function will be protected through patents, functional designs, integrated circuit topographies, trade secrets. And then we have that little circle of expression. And let me just quickly see, academics, how many academics are here today? Just none. Oh my goodness. Just 1. So this is actually geared towards academics. I'm sorry about this. But maybe you can teach them something then. And then the last circle is basically brand, our name, our trademark. So if I just want to tell you quickly about the project that we did for the Pro-Vice Chancellor, and in the South African higher education landscape. Normally there are 2 strands how intellectual property is managed. The first one is, of course, we have patents and inventions that can be patentable to protect that and to make money from that. And of course, this is well known at UNISA. And then the second strand is the management of copyright ownership, etc. Now, UNISA only started managing its IP in 2011. And why did we do that? Because of this. So the Department of Science and Technology started saying, listen, we are pouring all this money into research, and what are we getting? What do we have? We don't have a... very little return on investment. So as a result of that, this act was passed. It's called the Intellectual Property Rights in Publicly Financed Research and Development. And in terms of this act, all universities have to manage their intellectual property, and of course UNISA responded. We established the DITT, Directorate Innovation and Technology Transfer, and Ms. Ayanda Norma is doing very well. So we are managing that little part of IP because the government says we have to. But apart from, in other words, what are we addressing at UNISA? We are addressing only that core of the IP atom. We are only addressing patentable inventions. We are not addressing copyright. We are not addressing trademarks. And then, of course, we have a few policies, unrelated policies, and they have little bits of intellectual property in them. So we are doing this in a very uncoordinated manner. And of course, we have conflicting provisions. You'll be shocked. Anyone who wants the report, please email me afterwards. I have the very inelegant email address of Pistot. Pistot@UNISA. And of course, when I started here in 1991, when I got my email address, I phoned ICT. I said, listen, this cannot be my email address. And the person just said, listen, we don't know what you are talking about. That's your email address. So I've been Pistot for 25 years. And the only advantage is no one ever forgets my email address. So I'll send you this report, but you'll be shocked. We did a sort of a comparison of the conflicting provisions, recently adopted policies that define intellectual property differently, in some instances incorrectly. Our contracts, the IP provisions in them differ vastly. In other words, it's really unregulated, it's not managed at all. Then unregulated, IP and study material. There's no policy on who owns intellectual property and study material. It's not addressed in the policy. It's only addressed in one policy, I'm lying, the short learning policy, short learning programs policy. So there, Professor Peter Havenga was quite wise. He inserted a clause there to say, all material developed for short courses belongs to UNISA. And probably why? Because someone probably started to offer courses outside of UNISA. If we think of, I'm not going to address this in detail, but if you think of IP in community engagement projects, it's not addressed at all, and we face a lot of risks in community engagement projects. Because we develop something, we take it to the community, we leave it there. One example was an unconventional cooker. And we started saying, but you know, what if this cooker falls over? What if a child gets burned? What about quality control, etc., etc.? And then lastly, it's such a pity no academics are here. We do not regulate IP in research outputs. Of course, that's something that's very close to my heart. So if you look at this IP continuum, all the different types of IP, we only address that little bit. The rest remains unregulated. So there are 4 imperatives why we should do this. Of course, the public policy landscape, the fact that we are moving into OERs, and then there are lots of business risks. I'm going to focus on business risks for the benefit of the Risk and Compliance Division. And then, of course, lastly, we have to regulate this because what about the relationship between UNISA and the UNISA enterprises? You know, this new company that we formed? That no one really knows what it is going to do? That has not been addressed at all. So I'm not going to address that because I don't know what's going on there. So if we look at the public policy landscape, I just want to talk very briefly about this. Of course, partnerships between UNISA and external stakeholders have become very important. As a result, the relationship should be addressed. There's a huge tension between IP ownership and access of the public to that IP. I can just give you one example. If you think of the NRF recently adopted a policy that says any research produced by the funding of the NRF must be made open, publicly accessible. So they are openly advocating for open publishing. I'm also in favor of that, of course. But that has a huge impact on me. It means I cannot publish in any proprietary manner anymore. And these issues we should pay attention to. Lastly, scarcity of resources. I read yesterday on news24.com. I can't remember the name of the person, but it's part of the Fees Must Fall campaign, who has said, but lecturers should now start producing their own material so that students don't have to pay for copyright licensing. Quite rightly so. So these are all the issues we should think about. Of course, just by the way, you've heard I'm on the board of directors of Delro. So UNISA pays about 30 million rand a year to Delro, reprographic licensing. And then, of course, UNISA's OER approach. So I just want to say a few things about this. If you are going the open access OER route, you have to make very sure about the material you are licensing. Who owns it? Who created it? When was it created? Does it contain proprietary material? We have one person, Lawrence. Lawrence Claessens. Lawrence is the sole person in control of UNISA's copyright permissions. He only has paper files. In other words, if I'm writing a study guide and I want to include an extract from a specific book, then Lawrence will get permission and UNISA will pay the copyright owner. But whether that is followed up the year after, that is very unclear. So we have no policy to address this. We also have no policy to say what can we license when. If we look at this, now you can see this ends 2002. This is for businesses. If you can see the amount of intangible capital within companies. You can think what it looks like for 2016, probably mostly red. Now this is for businesses. Can you imagine for universities? Universities, it would be almost completely red, am I right? Because what does UNISA consist of? Of course, we've got buildings, we've got systems, but we are teaching. It is intellectual capital. So that's why it's a huge business risk. So if the main value, if UNISA's main business asset is intellectual property, and we are not managing it, something is wrong somewhere, I'm sorry. In 2005, UNISA's brand was evaluated, UNISA the name, as a trademark, and it was found to be worth about 150 million rand. So I think in today's terms, it would probably be, I don't know, maybe 3 times as much. If you think how we've grown as a university, I don't know how much, but much more. And that was a very good sign to me. At least UNISA evaluated the value of the brand. But then I found out why. It was basically just because people wanted to change UNISA's name. And as a counter-argument, we wanted to look at the value of the name. So that is a very good thing that we did there. If we look at the drivers, the business drivers, I'm not going to read through this, but in all 3 instances, your IP protection and maintenance is core to addressing the sustainability of this business. So the risks. IP does not form internal policy at UNISA at all. So that means valuable IP might be lost. And our disharmony, our confusing, conflicting policies means it might lead to damage and harm, and of course, lack of awareness, bad leadership. So just to highlight a few risks, I'm almost done. This is a bit legalistic, I think. So our core is offering tuition services. And the backbone of that core is, of course, our tuition material. So if that becomes conflated, what happens to the core of our business offering? Just one very nice example. You all know, in terms of the Copyright Act, Section 21(1)(d) says, whatever you create within the course and scope of your employment belongs to UNISA, right? So that means all research, all tuition belongs to UNISA, per definition. But as an academic, I routinely sign contracts to publish works that in other words, UNISA owns the copyright. As the owner, UNISA has the right of publication, reproduction, etc. But I just give my articles to journals and they publish them. So we can think, okay, maybe we can say there is an implied license. Because if a copyright owner allows certain conduct, you can say there's an implied license. But more seriously would be where I assign copyright, that's normally for publication in books. So if we look at the letter of the law, those assignment contracts are void, unenforceable. Because you cannot assign something you don't have, you agree? So if I'm not the copyright owner, but I assign copyright away, the publisher actually gets a null and void good. So who should carry the risk of those unenforceable contracts? Who should be held liable? Another issue on copyright, if we look at academic citizenship, copyright, who owns the copyright in blogs, presentations, and other research reports? More interestingly, what's the legal status of a hashtag? And what if I start a Twitter account, Tana Pistorius UNISA? I don't know if I can, and I don't know if I should, but UNISA should address this. Because there could be people tweeting all kinds of content about UNISA that UNISA might not want. and of attribution. In other words, we all know about the controversial Facebook entries of some of our management members, ex-management members. You know, where do we draw the line? If you have a Facebook account, to what extent do you align that to your needs or you don't? It's important. We should have guidance. And then lastly, outside work. Who owns the IP and that? We need to know where the line lies, especially then also conflict of interest. So I say we have the ostrich approach. The only thing management is saying is this must just go away. I think mostly because it's a very complex issue. But because it's so complex, the only thing that tells me is that it's an integrated issue. So it is something that should be addressed on policy level. So my conclusion is this is complex, but there are very clear imperatives why we should address intellectual property management at UNISA and why we should do it properly. And this is one example where we could lead change, where risk and compliance could take up the torch and go for it. And of course, with an IP strategy, I only spoke about a few things. But for an integrated IP strategy, you should have internal policy positions and external. And for the external, from a university perspective, the important one would be public policy. You know, in this world of fees must fall, open publishing, open access, plus a third stream income, somewhere there we should state our policy position. And of course, for internal purposes, it's important to do an IP audit. So I was very dismayed, and I raised it so many times, that the Electronic Content Management Project, the ECM, it doesn't address IP at all. So it sort of documents all UNISA's assets and all our documents, etc. It sort of puts it in a database, but it doesn't allocate authorship and any risks related to IP. And of course, the protection and maintenance strategy is very important. So with that, I can thank you for your attention. I'm open for questions. Thank you.